Well, then we have the second batch of law clerks from Bhutan. Vicky sharing and Ugen sharing. Welcome to Supreme Court of India.
Welcome.
My lord, may I mention?
I wanted to mention Amrapali that new bench is to be constituted. So the earliest period, because 12th of February, Justice Sanjay Kumar says that he cannot continue in this bench because some of his relation is there in.
We are constituting bench. I am aware of that matter. We'll do that.
May I mention?
Involving fish for us demolition.
Just take the mic and why this urgency?
Demolition for the 6th of April. We request for this tomorrow, the 15th of April. Otherwise, the matter will be entered in such.
Take the mic and then speak.
Lordship, I'd like to mention a matter involving fish workers demolition, which is scheduled for the 6th of April. We request for listing tomorrow.
No, there is no such urgency.
Lordship's demolitions may be conducted on Monday, so if maybe take.
With my lord's permission.
Defects haven't been passed.
Time and again been telling you that whosoever wants to show any urgency, please give it in writing to the registrar. We will examine immediately, and wherever we find, we will do it. Otherwise, second day, in any case, it will be listed.
My lord, may I mention a matter, my lords, in the constitution bench matter, my lord, we have filed the written submission, but with little delay, my lords, that could be permitted to be taken. In the constitution bench matter starting, female genital mutilation, we have filed the written submission, my lord, but with the little delay, if written submission could be taken. 4 days delay, my lords.
The 9th bench matter.
Yes, my lords.
All right, that is allowed.
My lord, in the Vanashakti matter, that's
Lord, I'll my lord give a letter, my lord, to the registrar, my lord. There's an urgent mentioning, my lord. I'll give a letter, my lord. I know your lordship. I'll do
in the
that.
Vanashakti
But,
matter that's listed today, my lord. The state of
Whoever has given a letter of urgency, we will examine it, and where we find
So
that
only-
there is an urgency,
Only,
we will list the matter tomorrow.
Right.
Otherwise, in any case, with the rule of 2 days after the curing of defects, 6th or 7th, the matter will be listed.
my lord, in the Vanashakti matter that's listed today. My lord, in the Vanashakti matter that's listed today, the state of Tamil Nadu, my lord, had filed a separate petition that's shown listed for tomorrow, my lord. So I have copies for the put. Very well.
my lord, only half a minute for that, my lord, because the nomination, my lord, I've been nominated to my lord, represent the Congress party. The last date is, my lord, 6th of, my lord, this thing. But my name is not there in the electoral list. So the appellate tribunal,
There is not there.
and the appellate tribunal is also not functioning. I don't know where to go, my lord.
Voter if you are not a voter.
No, the appellate tribunal is not functioning, my lord. So I'm not in a corner.
Just wait for another half an hour.
Great.
Appellate tribunal will become functional.
With my
I
lord's
see.
permission, my lords, we filed the written submissions in the 9-judge bench. Since the number was generated post 12, they're not taken.
Allowed.
Please.
Delay control in 9th bench, whosoever wants to submit today or by tomorrow, you can submit.
Yes.
That which we have received yesterday. DO letter from Chief Justice Calcutta High Court yesterday. And of course, both my brothers have also gone through. There is nothing as such, except that we are quite happy and very optimistic about the facts and figure given therein. So is it correct that out of 60,675 till yesterday evening, more than 47 lakh something, those have been disposed of?
Yes, Minister.
And with regard to remaining, on average basis, 1,75,000 to 2 lakh objections are being dealt with every day. And today morning, the Chief Justice has informed us that by 7th April, all objections will be decided.
Yeah, because we are very grateful for that.
May we give
We-
the status report as we have prepared minutes? Status report
yes,
on the
yes,
part
please.
of the Election Commission of
Now,
India.
only two things, yes, of course, we'll consider that.
Yes.
Now, as regard to the tribunals, on 20th March, the letter says, on 20th March 2026, the Election Commission of India has notified constitution of 19 appellate tribunal. Before that, the judges were shortlisted after consulting the party. That includes 4 former chief justices also. As reported, the Election Commission has introduced the appellate tribunal portal for the state of West Bengal in their website, and appeals being filed online and offline. A team consisting of representatives of the Registrar General of the High Court, Election Commission of India, and the state of West Bengal visited the following 7 places to assess the suitability of accommodating the appellate tribunal. Then 7 buildings are mentioned, including the Judicial Academy. And lastly, serial number 7 building was Dr. Shyama Prasad Mukherjee National Institute of Water and Sanitation.
We have taken permission for 8 weeks where they can commence, if necessary, shift over to Judicial Academy.
So the parties were unanimous that this institute is the best one having infrastructure, and it is in Kolkata. So you have got the permission.
Permission we have got.
So, and I think my brother has also fair knowledge about it. 21 chambers are there, rooms, which can immediately be converted as courtrooms.
We have informed,
So ready-made infrastructure available there.
we've informed the Honorable High Court also, Millets.
Judicial Academy.
And today, training is being imparted. Tomorrow onwards, they can start.
Institute of Water,
That
Joka.
Jal Shakti Board or something.
Jal Shakti.
Yes.
And I think other issue which we also flagged in the DO letter is that the parties are also unanimous that the appellate authorities venue should be in Kolkata, this place. Now, one thing you have to do it. The Chief Justice has pointed out the Election Commission of India needs to issue necessary notification orders accepting the suggestions of the Chief Justice regarding the payment of honorarium, traveling allowance, and other incidental expenses.
Millets, I am told we have already done that.
If they have done, very good. You please
These are the
give a
letters.
copy. We will place it on record.
Is it only one copy?
The,
Today, today.
the appellate tribunal members? Is
Yes,
it
today.
a one-day training?
I was told 1 day training, my lords. They could commence tomorrow.
But
There are four
so far appellate
It's half a day,
tribunal is
actually.
concerned, what training? Appellate tribunal will decide about this is a quasi-judicial authority.
The training, not in
Kindly,
the sense,
Just kindly let me, just.
familiarization.
If your lordships kindly allow me, kindly allow me to speak. The training was given to the designated officers earlier, to those who have dealt with. Training was given to the judicial officers. Now, one way, everyone cannot go. Now, the adjudication officer, the appellate tribunal is a quasi-judicial body. If a quasi-judicial body has to take a decision on independently,
Obviously, they will.
And
be
then what the-
Former Chief Justice and Judge.
no, I am submitting, my lord, kindly, just have,
Please tell us what is the point.
my lord, why the training? The quasi-judicial authority will.
This is only how to handle the computer, what are the
Yes.
documents to be seen, it's not.
Hand holding.
Why don't you
all-
go for training to them?
My lord,
Why will put you also there on for training if you want to go?
no, I do not want to go.
Then don't raise.
My lord,
privilege of
training, no, not the merit is concerned. Every time the training is given, the merit is concerned.
It's only orientation, my lords, familiarization.
My lord is not saying merit, he's saying only admitted.
Don't worry.
It's not training that they, how to, you will decide it. It's only how to handle. So today.
I have no difficulty, not on merit. my lord.
That's what my
And
lord is saying.
To operate a new laptop, I may not be able to, you may
But
not be able to.
No, my lordship is right.
Yeah, this is right.
They will, they are former chief justices and including
Yes.
Justice
Yes.
Shivagam, I think.
Yes, yes.
Manjula Chalu,
Justice Man from, coming from Karnataka.
No, there's no doubt.
Justice Shivagam coming from Madras, former chief justices.
No, correct.
they have vast experience
That's
in
right, that's right.
deciding matters. So, Mr. Bhattacharya, you need not be bothered about election commission officers influencing or in any way interfering with their decisions.
All that we want is if there are some administrative glitches, we should be allowed to approach the chief justice, nothing more than that.
Absolutely, why not? Why not?
Just observe that.
Sir,
Doors are always open.
That's right. Just observe that, Pulas.
And, Mr. Till everything reaches it.
Just observe that, that's all. Pulas. We're nothing more than that. We
In groups or like a delegation.
no, political, your lordships have on the other day
No,
observed.
no, then we will authorize Honorable Chief Justice to not to entertain them.
No,
You can't convert.
no, political party.
no.
No, not political party.
They have gone, my.
No. If the party has any, Lord, so far our understanding, kindly, Lord, so far our understanding is concerned, the observation was there, your lordship, if anyone wants to tell, communicate something in an administrative side, say something. That is the reason we have said about the, later we have sent it first.
Mr. Kalyan Bandyopadhyay, you can go, Advocate General can go on behalf of the state. If there is some other.
That's
Any,
fine, man.
possibly it was my wrong understanding. My lord, I am taking it. It was my wrong understanding. Your lordship said
You being
any
there,
party.
You being there, where is the necessity of the political workers to go?
We agree, mother.
Not the political
All-
workers, my lord.
They don't.
No, Mr.
Let us not-
Bhattacharya, this problem is, to the best of our information, representations by political unions or associations are being made not only to the Honorable Chief Justice of the Calcutta High Court,
Correct.
but also to the district judges in the various districts. Now,
No, that I do not know.
Yes.
That we do not know.
when
That we do not-
find out, it
That
is
we-
advised of the situation.
That we do not.
So we do not
I
want
appreciate that. I appreciate that.
to be disturbed by these sort of
Yes, yes.
representations.
That's right.
Whatever, let us
Lord,
make it
Your lordship observe that, in fact. No issue on that.
form of grievance.
Menka will also play double role. There she might have different role, but here she will.
No, I am not playing. I am not. My lord, one role I am playing. Kindly, my lord, your lordship is, do not mind. We are also busy for the election.
Naturally,
We are also,
Your
this is not our important job now.
your
First,
democratic
Just,
exercise will be definitely a part of the electoral process. But the thing is that these judges, they have been really called upon to perform an exceptional duty, which is not within the common run of their
That's
judicial.
right.
very nice, Lord. Since your lordships have,
Situation.
since your lordships have,
They are subjected to representations from various political views and insinuations being made, well, you have been siding with A or you have been siding with B. It becomes very difficult.
Very nice.
for
No, my lord,
the-
your lordship is absolutely right for us. There's no
Lord.
doubt about it. We'll make sure that the representation has no political color.
You are there, Mr. Bandyopadhyay and Dr. Goswami are there. Please, any person having a grievance about a
That's right.
decision of a judicial officer, the appellate tribunal is there.
Fair enough.
It's manned by judges who were former chief justices of the
That's
Calcutta High Court. And we have no reason to believe with regard either to their competence, impartiality or capacity. Please advise anyone who is aggrieved, either in the inclusion, unfair inclusion or unjustified inclusion, or unfair exclusion, to approach the tribunal and let the quasi-judicial exercise be undertaken in that objective manner. One thing we need to clarify, because in the last occasion, there was, and the Chief Justice has also in his report flagged the issue of reasons. I was not aware that the software prepared by your client, Mr. Naidu, also has a field where remarks or reasons are given. These remarks or reasons, therefore, is available in the software itself. So if it is possible, whenever a person approaches for an appeal, he may be supplied with the reason, or arrangements be made that whenever an appeal is filed, the appellate tribunal will provide
Will be given.
to the party concerned
Absolutely.
permission to
We will.
end the appeal.
That's all we want.
Absolutely.
Which have been raised.
We'll just pass on the whole record. We'll place the whole record before the appellate authority.
Yes, and also the appellate authority will have the right to share it with the aggrieved person and also anyone who's participating.
And the appellate tribunal will also should have the reasons.
Yes, that's
I
good.
mean, wherever
We
there
do
is a-
abide by that one.
Wherever there is a dispute with regard to genuineness, authenticity or validity of a document, let the tribunals verify it from the official records. They must ascertain the genuineness of such documents and take a final view, whatever.
So be it. Yes.
Only one thing, Milord, kindly do not.
Try to mention.
Yes,
Milord,
Mr.
we have never said against.
Mr. Bandyopadhyay.
Kindly unmute Mr. Bhattacharya, my lord.
Yes, yes.
So he
Mr. Bhattacharya, you want
try
to
to make
some?
submission.
Yes, yes.
I'm-
Mr.
I have not been unmuted.
Yes, yes. you
Yes.
unmuted
There was a
and you are
humble
very
appeal.
Okay.
The humble appeal is below that the tribunal authority will consider below the documents and records which should be supplied by the applicant. That clarification is not called for. Otherwise, the appellate tribunal will go by below the documents which are not there.
Mr.
That
Bhattacharya,
will be
we are
called
making
never-ending
it
process.
clear because on the last occasion, we made some comments without being
Yes.
aware of the architecture of the software. The architecture of the software provides for a field where remarks or reasons are given by the officers concerned while deciding whether the logical discrepancy was justified and therefore deletion warranted, or it was not justified and therefore inclusion is directed. In such cases, whenever an appeal is filed by an aggrieved person,
Yes.
be it the representative of ECI who feels that the inclusion is unjustified, or be it the person who has been excluded, the reason shall be supplied to the person concerned.
Right.
And the person concerned will have, subject to what the tribunal deems fit and proper, the manner in which he is going to rebut the reasons. It will not lay down
That is there.
Be it on the basis of the documents which are already there
Candidate.
with regard to its authenticity or any other unimpeachable
Yes.
document.
Yes,
Just-
yes. So that should be part of the order.
That's
If we are
fine.
time
That will
constrained,
satisfy us.
if they are
That will
given
satisfy
another
us.
round to have fresh documents placed,
Mr. Naidu,
yes, please.
we are looking at two different, very independent exercises. One is what is the list on the basis of which the election is going to be undertaken.
To be held.
Another is a vital constitutional right to vote.
Yes.
Now, even if a person is excluded today and is unable to vote in this particular election, but that exclusion appears to be unjustified to a tribunal headed by a former Chief Justice, we see no reason why the decision can be altered and he be included. And the likewise, a person incorrectly included and votes for this election and your representative makes a report to the tribunal, we see no reason why the entire cleansing exercise taken by you should not be taken to its logical.
Indeed, Millets, we are only worried about the time frame. There should be a cutoff date for that inclusion or exclusion.
Cut-off date.
And Millets, they have given ample opportunities to file the documents.
Time frame, we cannot decide. It would be the appellate tribunal who.
Yeah.
In terms of that, Millet, the notice, last date for nominations, it can't be beyond that.
We are not saying that.
Yes.
The appellate tribunal decision, if they are within the last day, may be included. But those which spill over beyond
Yes.
the last day or the days that we are making a cutoff
Exactly.
may not be possible to be included in the supplementary list. However,
The right needs to be established.
their right cannot be washed away forever.
Yes. That's the fundamental thing.
It becomes an extremely oppressive situation.
I've only flagged the point, Millets, with regard to documents. Then it again, a sort of rigmarole, everything opens up. If they file fresh set of documents.
How can new documents be allowed? Because otherwise there will be an unending
So
process.
the documents within the specified list must be considered.
If they have been there, they could be considered.
Manoj, may I just come in for, just very briefly?
Other point, not is
A
that,
very important issue I wish to flag. Just very important.
let me finish, I believe.
Just 1 minute, Milord. Milord, kindly see your lordships by various orders. Observe that all claims and objections should be filed by 14th or 16th February of 2026. And thereafter, the final voter list will be published. Now, final voter list has been published on 28th, and thereafter supplementary voter lists are being published. Now, Milord, the Election Commission has issued a notification. The notification is saying that if one wish to file Form 6, that time is extended. And Milord, under the scheme even, the final up to before voter list, final voter list, on the basis of a draft voter list, anyone can raise objection. Your lordships also made clear. Form 6 cannot be done at this stage when the adjudication proceeding is going on. And bundle forms of harm, I am not blaming any political parties.
Today, these things are completely premature and hypothetical. Let us see that how the balance of the pending work is completed by 7, and ultimately what scenario emerges. It's not that neither we are closing today nor.
Yes.
We'll see, let us see then.
Fair enough.
Required, we will intervene to the extent possible.
Kindly see the notification has been made.
Mother's name is not in the list. She's 80, Milord. Some priority may be given in the tribunal.
Milord,
Yes.
The way you are
Standing behind Milord about.
please, the way you are making out a case before us, please go and make out a case before the tribunal.
Yes, but with some preference to the proposed candidates. For
My lord, kindly
consideration.
see
That
the
will do.
notification. My lord, 27 March 2026, this notification has been made by the Election Commission. 27th March 2026, this notification has been made by the Election Commission.
That form
Form
6
six,
can be
that
filed.
6. Time has been extended.
It's an ongoing process, Millet. When it comes to Form 6, they talked about exclusion, now they're talking about inclusion.
60 and ongoing process.
Millet, Form 6 can be given by any fresh voter. Suppose I complete 18 years today.
Under the 23, under
Yes,
section
Millet.
21, when you publish the final list, the persons who are at the cutoff date will be included. Beyond that, there cannot be any inclusion.
The cutoff date is the last date of nomination.
Is in respect of the draft list which is already published.
May I submit, Millet?
Draft list published
The-
with logical discrepancy under adjudication is the only thing.
That's one part with regard to disputed ones. When somebody acquires citizen, but rather the voters' right, say for example, Millet, I complete 18 years today. I complete 18 years, I can apply tomorrow.
Extend it till the last date of.
That's what the law is, Millet. Kindly have a look at section 23 minutes. Until the last date of nominations, the inclusion could happen.
Thousands
somebody
of
is
forms are
indicated-
being filed.
It's an ongoing process. They're undisputed ones.
Bundles of forms, thousands are being filed.
Vis-a-vis the disputed ones.
Can you see the Rule 13? Rule 13 speaks about
One-
form for
One,
claim.
Mr. Kalyan, this issue is not before us.
Okay,
The
I understand. Milord. I appreciate.
issue not before us.
Milord, I appreciate.
Please raise this issue there before the authorities.
Yes, your lordship will give us liberty to do this.
let them adjudicate. Before the
We have done it. My lord, we have done it. We have done it. 20 itself, we have done it 28th.
May I read minutes?
Lord, I can't show your lordships a video. Your lordships will be surprised to see. The video will show that blood bundle in the CICO's office. In the CO's office.
My
That's why we have set up 21 tribunals. Now we show these videos.
No, it's on Form 6, brother. He's talking about.
My
Form
lads,
6.
About Form
until now,
I
the
am
grievance
restricted
is
to Form 6.
exclusion. Now they have come up with the
restricted
the
to Form 6.
inclusion. Kindly have a look at section 23(3) minutes. That's been explicit. If somebody has a right, we can't thwart.
No, but
But if somebody can't have, it has to be stopped. It's as simple as that in my humble submission.
nobody will be able to scrutinize these forms.
Same manner, somebody will have a right to objection also.
That's correct.
Indeed,
That's
my
the
lords,
problem.
anybody can.
That's the
Most
problem.
competent appellate forum has been created. They can,
Chief Justice has indicated that whenever this sort of a situation is occurring, you put your objection on the Rule 7, Form 7. rather.
My lord, kindly.
Form 7 is
My
objective.
lord, what is happening, my lord? Kindly see, my lord. Your lordships have, in this matters have, really we are grateful that your lordships have, even bypassing the statutory provisions in a peculiar circumstances, your lordships have laid down certain mechanisms. Right? Considering everything. Now, considering the everything, the adjudication proceeding has also gone appellate tribunal. Now, all of a sudden, kindly, just I am saying, my lord, and I require, I will come up. All of a sudden, 30,000 Form 6 are being deposited by one individual.
Mr. Kalyan, this is absolutely not unusual. It happens in every state. The exercise under 6 is altogether different, but it cannot be done in a hidden manner. Something that if you have a right to object to it, and once you file an objection, it is obligatory. upon
But
the
we will not know, Manoj. They'll have to display the list.
Yeah,
The
if that is
problem is we will not know.
procedural part, you know very well.
very, my lord, if that, my lord, kindly, just one clarification, my lord, just nothing I am saying. If any Form 6 is being decided by them, it is concerning the booth is concerned, not the CO office. All Form 6 which have been deposited by them, be notified in the booth itself,
So that we can file an
Yes,
objection.
so that we can file the objection.
Rule 26, sub rule 3.
Whatever you are arguing today is completely verbal. There is not a word before us. We have not read it, we have not seen it, we have not.
All right, my lord, all right, all right.
Millets once forms.
Please appreciate.
Aye.
the
I have deeply obliged.
Right when we open the.
My lord, your lordships is considered. My lord, maybe we are very, I understand that, my lord, but your lordship is
Go even to the extent you might be having a genuine anxiety. But then there is
Can raise forms.
but definitely you are not remediless.
not.
Definitely you are not
My
remediless.
lord, we are really, my lord, very
No, we'll go
under
on. Let us-
tension, no doubt.
On
no
the
doubt
last
about it.
occasion, will
But your
this court
lordships
observe
Form
that the
6 is
taking
given.
care of that.
Once Form 6 is given, under Rule 26(3), it has to be published in a conspicuous place. Objections could be invited, and in Form 7, then adjudication takes place. They can always, anybody has any grievance that can be
But
ventilated.
what is the qualifying
Nobody's-
date under
nobody's
the
case that-
statute, my lord? There has to be a qualifying date
given
with
an-
the statute.
23, whatever 23 deal with that.
No, no.
23
Qualifying
minutes.
date is how the chapter starts. It defines what the qualifier, it'll be 1st of April or 1st of July.
So I think
Now they have arbitrarily changed the date,
That's the problem.
opening the floodgates against the statute by claiming some back route of the rule. Anyway, it's not before you, but just so that your lordships know, this is what is happening.
Millet, the statute speaks volumes. May I read that one, Millet?
First July was the qualifying date. Now it's whatever date.
No amendment, transposition, or deletion of any entry shall be made under section 22, and no direction for the inclusion of name in the electoral roll of a constituency shall be given under this section after the last date for making nominations for an election in that constituency or in the parliamentary constituency within which that constituency is comprised and before the completion of that election.
This has nothing to do with
This is
rules.
what they have to do with regard to Form 6.
Nothing to do
And
with
when
rules.
then Rule 26, sub rule 3 comes into picture. It has to be published in a conspicuous place. Anybody has any grievance or objection that can be filed in Form 7. Adjudication takes place. This is completely different from the adjudication undertaken by the judicial officers.
See, there are two differences.
My lords.
One is an amendment of the electoral roll.
Correct.
Another is the electoral roll which goes for polls.
Yes.
The electoral roll which goes for polls is as per the qualifying date,
Yes, that's correct.
which is announced by the ECI.
Section
It
14.
was announced
That is
by
also
the
in 26,
ECI at a
Rule
particular date, and that is why we had to pass the order that supplementary list shall be
Yes.
released
Exactly,
from the
exactly.
state. That does not take away
May I read?
a individual's right to include himself under Form 6, but that will not, his inclusion will not give him the right to vote in.
Exactly.
May I sub-
That's exactly.
May I submit, Millets? Kindly see Rule 26, Sub-Rule 1A. Kindly see that, Millets. Every such application as is referred to in Sub-Rule 1 with reference to qualifying days, that is to say the first day of January and first day of April, the first day of July and the first day of October of the year shall be presented to the registering officer in such manner as the Election Commission may direct.
Which is a post qualifying date. So anybody who, everyone who has the right to be included. And if it is included before last date of nomination, I will be given.
No.
23.
Be included in the electoral list.
It is a dynamic process.
Does not dwell on it and make a final
Because
opinion on
program
this.
is there, but nothing is before us.
If there is,
Because
if there is an objection, raise the objection.
We'll do that. We'll do that.
And we will.
We'll do that.
But I have
Could
a
I-
humble
Lordship,
appeal
give
below
us
that
that liberty,
kindly,
because we
kindly
don't want
below direct plus some preference
But we
to.
have brought it to your lordship's notice. It's only fair. Your lordship will note it.
Order.
Mr. Diwan, yes, one. That's
Yeah,
enough.
Millards, there's just one point I wanted to make.
Lord, I have a,
You already
my lord, I have a submission, my lord, in 1.4. Would your lordships hear me? If your lordships are hearing Mr. Diwan after that.
Mr. Giri, we will hear you also. Let Mr. Diwan from
Very
his side also say.
Very well.
Yeah, but there's just one point I wanted to make, which I'm grateful to the Election Commission for having furnished its latest status report. What we were planning to hand in terms of a note, I think is overtaken by the communications received from the Chief Justice, because that has even more recent statistics. But the point which we wish to make is that on the basis of the information which we have, the degree of inclusion from those approximately 40, your lordships had a slightly larger figure of adjudicated cases now, inclusion rate was about 55% at 19 lakhs. And the exclusion rate, the people excluded pursuant to this adjudication exercise, was in the range of 45%. That's a very, very high exclusion rate. The reason I'm pointing this out is because your lordships can now envisage what is likely the burden before the tribunals which have been established and which are going to start functioning now. So this is there's a very, very high rate exclusion rate, keeping in mind that these are all mapped individuals who have been excluded on the basis of this exercise. One of your lordships know.
On this issue, we will not make any comment for the simple reason. They will assert that 100% were liable to be excluded. This side will say all 100% were liable to be included. Now this again becomes a contentious and adjudicatory issue.
Yeah, so Manoj, the second point was that I'm very grateful to the observation made that the short reasons will be communicated, because otherwise the person is going blind. And I think what your lordships have noticed, that if it is mapped or if it is available on their data, then that should be shared so that a person really knows when he approaches the tribunal.
That we could visualize well in advance, and that's why with these appellate tribunals, that institution.
Very grateful.
No,
very grateful. And frankly, these 19 lakhs or so who have been included and have been re-enfranchised or enfranchised because of your lordship's directions is a great
because
boon.
of your lordship's orders.
Yes,
There are
that's
2 million
a
voters
real step forward.
On one hand,
I have one.
Otherwise they were
I have
excluded.
one submission to
with
make.
regard to the discrepancies. Judicial officers holding about 45%
That's why on
discrepancies.
lighter side we are pointing out. Your assertion will be all 100% should be excluded. They will rightly assert all.
Millets, imagine Millets.
One request.
May I have one humble prayer?
One request
Let
is
the
this.
proposed
Kindly-
That was decided.
One request.
Things could have
Kindly dispel the idea that we have blamed any judges, those who are in the adjudication. We have not done it, my lord. Kindly just-
Mr. Kalyan,
I have just request to your lord.
we have verbally pointed out. You have appreciated that part. Matter ends there.
That's right.
Matter ends there.
Okay.
Why unnecessary?
Manoj, my final request is, would your lordship,
All right.
That's only
but
because when senior, Senior advocates, seasoned advocates are there. We can only communicate something through you people.
Yes, yes, yes.
We can't directly tell anyone.
No, no, no.
Tell you only.
All right.
May I make a very
That Mr. Kalyani is
that
not
humble prayer before your lordship?
leader of the bar also.
Yes, yes.
Yes, yes. Of course, my first love is the profession and I am the officers of the court. That I always say
That is
everywhere.
my final point is, would your lordships consider placing the matter on the 6th? Would your lordship consider placing the matter on the 6th? And the reason I mention this is by then we will have considerable experience of how the tribunal is able to deal with the load, because that might just give us some space and time for appropriate direction. So that's my final request. I'm grateful.
Mr. Duran, you are right. We are also tentatively thinking either because the Honorable Chief Justice has informed us today in the morning.
Correct.
And he informs us because he thinks it's duty to update us about all the administrative exercise. So
Yes, yes.
He has informed us that by 7th they will complete this book. So what we are thinking that on 7th we keep this matter at 4 p.m.
4 p.m., that's fine.
One humble request, will not let the proposed nominees of political parties, will not their application be had will not little preference. Otherwise, will not they will not be able to contest. Therefore, the political parties have proposed some nomination. Their will not claim be considered will not with some preference, so that they can have sufficient time to contest. This
Any person who is deleted and has been proposed as a candidate by a recognized political party can make a representation, and his or her case will be appropriately and promptly dealt with.
Fair enough.
The administrative glitches vis-a-vis the appellate tribunal process, the Advocate General may be allowed to make a representation.
That's all right. That's
to
no,
this.
that's all right.
Specifically the Advocate General, nobody else.
We are not saying anything. Please let us trust the tribunal because they are mostly very seasoned judges.
My lord, it's not about the decision makers, the administrative glitches vis-a-vis the process.
That
Because it's a new process, my lord. That's
Dr.
not
Goswami approached the tribunal member. The tribunal member has sufficient experience to deal with an administrative glitch, and if so, the tribunal member will definitely consult the Chief Justice concerned.
If your lordship
Any issue is
record this observation.
In a lighter note, I am requesting Madam Goswami to stay at Calcutta and request all these things to the Honorable Justice in administrative side. My burden will be some lighter.
Yes, Mr. Giri, you were saying something.
Lord, in 1.4, that's filed by the Sanatani Sangsad. There was an application that was filed, my lord. There is a diary number, but it has not been numbered, my lord. We have to bring to your lordship's notice something which we will believe is serious.
Has it been filed?
Yes, yes. In the morning it has been filed. I think your lordships may take it up
We
in
can only list on the next date now. Unless, no, you want to point out, sir.
We just wanted to point out something, my lord, so that if necessary, Dr. Guruswamy or somebody may probably would like to get instructions on that, and the election commission also. But if your lordships kindly come to page 9, paragraph 20, or even before that at paragraph
Maybe have a
14
copy,
on.
Mr. Giri.
Yes, I have
Sorry,
handing over a copy to Menaka.
maybe have a.
It has been served on the state council. It has been served. It has been
What do you want to point out from paragraph?
starting from page 7.
We don't have a copy. ma'am.
Paragraph 6, page 6, paragraph 13. Hand over copy. Hand over copies first.
We respond if we know what we're responding to.
No, it has been served, but I'll hand over copies. As per the data received by the Inquiry Committee of the National Human Rights Commission from DGP, West Bengal during the period from 24/21 to 26/21, a total of 1934
Now,
complaints.
ultimately, para 17 probably you want to highlight.
Yes. Therefore, only 2.88% of the accused were arrested and most of them are now free on bail. Several teams of the Inquiry Committee visited 311 spots for inquiries and ironically found that in 188 instances, FIRs have not been registered by the police at all. Even in 123 cases where FIRs have been registered. No, my lord, please come to paragraph 20.
Then please add CBI as a party in this.
We'll do that.
Because CBI
Yeah.
was entrusted, to the best of my knowledge, by
Yes.
a bench presided over by the then Chief Justice,
Yes.
transferred the investigations in these post-poll violence
Yes.
cases.
Yes.
So the CBI to answer
do-
as to why
we'll do
arrest
that.
was not made.
My lord, could your lordships kindly give me a minute? My lord, please come to paragraph 20, which is
When
of topical.
we have seen, it is not, the person was not even present who has averred this petition.
Sorry, my lord.
The person who has made this averment says statedly, see the pleading,
Yes.
statedly, and it is not true to the knowledge of the
My lord,
defendant.
that's a link to the video.
So that's what we are
That's a
saying.
link to the video. But the video, the authenticity of the video, my lord, could be
Nobody
denied
knows.
or could be
He
affirmed.
was not present.
My lord, I don't. One has to look at the video,
You bring it to the notice of the authority.
which we will do. No, my lord, the reliefs that we have prayed for. No, my lord, this is why this is of importance, my lord, is that because the state is
And the
leading.
CBI as a party with regard to the post-poll violence, what steps they took with post-poll violence?
Sorry.
At CBI as a party first.
No, my lord, we'll definitely do that. Please have a look at, my
Because
lord.
paragraph 15 to 17 are with regard to post-poll violence and
That's,
poor arrests being
my
made.
lord, it's part of the narrative leading, my lord, to the reliefs that we have prayed for now with this. Because we don't want a repetition of what happened.
I have a suggestion. Can this application be listed on some day? Let it be served on us, because before impleading
Just-
people, except we don't
let
even
me
know who
just
this party is.
It's not,
Who is this applicant?
it's not been served.
I have served.
Matter,
I have
matter
actually
vis-a-vis the.
No, it's not listed, it's not numbered, there's nothing.
How
Just
servers.
out of the-
Whatever my brother has been able to recollect, because
Yes.
this in 2021, when this
Yes.
then probably full bench of the High Court had referred the matter to CBI.
Yes, my lord.
And that matter has not landed here in Supreme Court.
Yes, my lord.
So why don't you move an application in those proceedings before the Honorable Chief Justice or before whatever, whosoever the bench is dealing with those things?
My lord, the whole matter is there before your lordships now. And your lordships, what we have prayed for is to set up a monitoring committee, my lord, probably headed by a former judge of this honorable court. And this is the first relief that we have prayed for. And steps to avoid, my lord, a repetition of whatever had taken place in
What is
2020.
the point of bringing that up today?
No, my lord, please consider this.
What
And then if
consider?
your lordships, after hearing my learned friends, or whoever is, my lord, interested in this, and then your lordships may
The
consider
learned
whether.
Chief Justice in
The-
Calcutta is aware of this. If there are any issues, obviously it will be dealt with.
No, my lord, see.
know whether-
We don't even know what these allegations are.
The first prayer is direct the high-level monitoring
Any
committee.
order.
Unnumbered, unlisted application on
No,
behalf
this
of a
is-
third party.
This doesn't get them anywhere.
Subject to curing of the defects, the say on the oral mention, an application in repetition numbers, a paper book of the unnumbered IA in repetition number 1216 of 2025 has been handed over in court. Say subject to curing of the defects, we register directly to list the application on the date fixed, The copies may be circulated to the party.
Very.
Well, that's fine.
But we them to file in the Congress.
Great.
My lords,
Deeply obliged.
my lords, petitioner in person in item 1.5. I am grateful this honorable court has
Sir,
placed this
we have
order.
spent 1 hour in this matter now. Please spare us.
My lords, I did not get any chance. You just,
I think what, all the issues have been broadly.
no, only 20 seconds. My lords, only 20 seconds.
May I
I'm
add one
grateful
thing, my lord,
this
for
honorable
DCI?
court has placed this matter before a three-judge bench. My limited submission is that this raises a pure constitutional issue requiring independent consideration. My lords, the impugned enumeration form is not prescribed under the rules and therefore lacks authority of law to compel disclosure of personal data. This raises an Article 21 issue. This issue is not state specific and may kindly be recorded independently. I have a short note, my lords.
We will consider the point which you are raising is a very important constitutional issue and we will examine in due course. ये elections से निपट ले एक बार फिर करते हैं.
But this election also is very important, my lords, because this is a complete violation of constitution. I've got small short notes.
All का election सबके लिए अधिक हुआ है इसको.
But this is not state specific, my lords.
This
is
the things are moving in the right direction in a very you must have seen it now. The initial most of the issues have been resolved either through judicial intervention or amicably and with the mutual understanding of the side, both sides. You are also helping us. Let us first see that the democratic process is peacefully over, and then the other issue which you are raising, we will consider in due course of time. So that we will not close your issue.
May I submit one thing? For election commission. 6th is the last date for nominations as per the schedule. And we need to come up with the final list by 6th evening or midnight, whatever. Because millets beyond that, no nominations can be accepted. Assuming that 7th, somebody could be cleared in terms of this adjudication, he can't contest, nor can he do anything with regard to that one. Good, my lords, for phase 1 millets, 6th being the cutoff date, let it be listed 7th morning. We'll request the Honorable the Chief Justice to have the whole thing completed by 6th midnight or whatever the time.
7th.
Because we have to come up with the list by that date.
We have constitutional bench. 9.
That's why 4 o'clock.
Either we can list on 6th in the evening.
6th evening millets.
Or 6th, 4 p.m.
So be it. 6th evening. To take stock and to have the next course of action.
We can list even on 7th morning also. That will slightly delay our sitting of the 9th bench.
But complete picture could be before your lordships.
Then it will
11th at 4.
Complete picture could be before your lordships by 7th morning.
Yes, otherwise election can't be held.
And the entire machinery to identify those 152 constituencies.
Yes, ma'am. That we have been.
Closing on 6th.
6th.
So that all the logical discrepancies in those constituencies may be
Get finalized by the date.
because the other can.
They can
And
wait
wait
because
for
we
a
have got
couple-
up to 9th.
3 more days.
So be it. That's what we would like to bring to
Please
your
help
lordships.
because
We do.
we
do.
Neither the judicial officers nor the chief justice, without the assistance of the election commission machinery, won't be able to identify the parts and the constituencies which have to take.
The process is on, millets. We'll represent to the Honorable Chief Justice there and see that that gets concluded by that
That gets concluded by 6th.
6th night.
And remainder can go up to 7th or 8th.
Yes, 7th, 8th.
8th. You are raising, that is answered by the statute.
Indeed, it's been answered by 23-3. Grateful, deeply obliged.
6th, on 10th March 2020.
He's passing an order in reference to.
Grateful, millets. Deeply obliged.
Petitions were issued through a self-speaking order. After taking notice of the disposal of objections by more than 500 judicial officers from the state of West Bengal, along with 200 officers from the states of Odisha and Jharkhand, to whom an extraordinary exercise of adjudicating the objections in the ongoing SIR in the state of West Bengal were entrusted. It was also resolved through that order, Honorable Chief Justice of the High Court at Calcutta was requested to identify some former Chief Justices / High Court cases for the purpose of constitution of appellate tribunals, so that the Orders adjudicating objections passed by competition officers would be appealed by the aggrieved party before such tribunal. In addition, directions with respect to payment of honorarium, traveling allowances, and traveling, boarding or lodging, etc. for the judicial officers were also issued. As per, after the order dated 10th March 2026, two communications have been received. We have received two communications from Honorable Chief Justice of the High Court at Calcutta. While Chief Justice के लेकर गए, नहीं पहले वाला है. While DO letter dated 21st March 2026 from Honorable Chief Justice updated about the progress, updated the court disposal of objections by the judicial officers. Besides, the proposal to publish the first supplementary roll on 20th March 2026. Honorable Chief Justice also flagged certain issues in the said communication which have been addressed in due course of time. Next paragraph. There is another communication dated 31st March 2026, which we have received yesterday from Honorable Chief Justice of the High Court. From informing that as on 31st March 2026, till 4:04 p.m., 46,60,135 number of objections have been decided in the entire state against the total penancy of 60,06,675. We are informed that by now, the total disposal has closed 47 lakhs. 47 lakh 30,000. 47 lakh 30,000. The DO letter further points out that on 20th March 2026, the Election Commission of India has notified constitution of 1919 appellate tribunals in the state. These appellate tribunals are headed by former Chief Justices, senior judges of the High Court. A team of representatives of the High Court from Election Commission of India and State of West Bengal, thereafter inspected, have visited various buildings in order to find out a suitable application for the appellate tribunals to function. Eventually, Dr. Shama Prasad Mukherjee, National Institute of Water and Sanitation, which is an institute run by the Department of Drinking Water and Sanitation, Ministry of Jal Shakti, Government of India, has been was shortlisted. As the said building was found ready to move accommodation, ready to move accommodation consisting of 21 chambers. We are informed by Sri Naidu Learning Council for the Election Commission of India that necessary permission from the Ministry of Jal Shakti has been obtained, and thus
for 8 weeks we obtained. For 8 weeks to begin with.
then for a period of, initially for a period of 8 weeks, so that the terminals become functional immediately. He further informed that the orientation stroke training to the members stroke presiding judges of the appellate tribunals will be undertaken today during the course of day, so that they are well conversed with the with handling of the appeals which have been filed online stroke offline. Handling of so that they can conveniently handle the software where the for dealing with the appeals which have been filed online stroke offline. It goes without saying that the Election Commission of India will either seek further extension from the Ministry of Jal Shakti and or another alternative accommodation shall be identified in consultation with all the parties, in consultation with the parties. We have clarified that the appellate tribunals shall function at Kolkata. At Kolkata. Next paragraph. As regard to the issue of issue relating to non-availability of regions को comma में कर देना, regions, as pointed out by Lord Chief Justice in the above mentioned communication. Commercial Naidu Lord Senior Counsel for the Election Commission of India informs that the appellate tribunals will have access to the to the record which was placed by the parties.
Yes,
before the adjudicatory authority, namely the judicial officers. That it will be ensured that the members of the appellate tribunal have access to the said record for the purpose of deciding appeals that may be filed, one eye, by the persons whose names have been excluded from the voter list, two eye, or by the authorities of the Election Commission of India who might be aggrieved by inclusion of certain inclusion of the names in the revised in the inclusion of names by the adjudicatory authorities. Next paragraph. It goes without saying that the appellate tribunals will share such documents and the appellate tribunal, or you say in order to clarify, so in order to remove any sorts of doubts, we request the appellate tribunals to have full access to the records which were placed before the records of the judicial reports along with the regions assigned by the judicial officers while adjudicating the objections and decide the appeals that may be filed before them after apprising the parties with such reasons. After apprising the parties with such reasons. The appellate tribunals shall be at liberty to evolve their own procedure in accordance with principles of natural justice, and are requested to adjudicate the appeals that may be filed by the parties after giving them adequate opportunity of being heard. So, however, we request the appellate tribunals not to entertain fresh stroke new documents which were never the subject matter of adjudication before.
That will, if anybody wants to rely upon document, scheduled document, that should be considered.
right, not to confirm first documents unless without verification, without verifying their genuineness and authentication.
Yes.
Fair enough, fair enough.
Fair enough.
That's good.
Is necessary for verification of
Fair enough, that's fine.
parties. Of the parties. Next paragraph. The only other issue, like by Chief Justice of the High Court, is regarding non-payment of honorarium. Honorarium along with travel, boarding and other incidental expenses. So in this regard, Sri Naidu and Senior Counsel for the Election Commission of India has placed on record the communication dated 25th March 2026 addressed to the Chief Electoral Officer West Bengal, directing him to release the necessary payments to the Appellate Tribunal, to the members of the Appellate Tribunal, to the staff, etc., and to the staff, etc. So, in order to expedite the issue, we direct the Election Commission of India, Chief Electoral Officer West Bengal, to release the necessary, to make the necessary payment to the officers, and members of the Appellate Tribunal or other allied staff, if any, in accordance with the recommendations made by Honorable Chief Justice of the High Court.
My lords may consider.
The precedents will have a consideration of the proposed nominees that will be recorded.
Issue may open a Pandora's box. Documents have been filed, they've been scrutinized. If there is any defect, that could be pointed out.
To leave it to the discretion of the appellate tribunal.
Appellate tribunal.
That must be, in fact, restricting the discretion of the appellate tribunal. If, let us say, an unimpeachable. Yes. Go on Article 227.
That could have been filed minutes when they had been given an opportunity.
This is surely not adversarial.
That's not an issue.
Why should CCI be concerned, Mala?
Yes, the whole process gets derailed.
Including voters.
No. ECI should not be bothered with that.
We only wanted the genuine voters to be there.
Yes.
And of course.
Yeah.
Not, we are also want to see that not
opportunity was given to
voters
file
are
your
not
document.
included.
You don't find
High
the
Court Judge,
documents.
Chief Secretary, all were excluded.
No. When ample time was given to file documents, you don't file. I know you
The
cry
name of a
foul.
retired judge has been deleted.
Accepted documents which should be allowed to be placed.
Yes.
Investment in excluding people from voting.
Very unfortunate.
Genuine voters who have voted.
Yes, that's why 45% is genuine voters.
We'll see to that.
So why the elections?
When it's appellate tribunal.
They were issued after the election.
The tribunal will know what to do.
All the other very Chief Justices, senior judges.
Election Commission have done a very bad justice how to function.
What has been mechanically rejected will not be reopened then.
On that. We will give it to the tribunal.
Discretion, whatever they
Yes.
That is, the only precedence of consideration of the proposed nominees may be recorded, otherwise it will not be done. If it is done at the last moment, it's difficult for them to contest.
That the tribunal will take it into consideration that such document was not submitted earlier and there should be a justification as to why it is being submitted.
The Chief Justices of High Court. These people are not. It's not direction.
But when it tells that the new document is to be verified. That
By whom?
by issue of
It is for
But
them to decide.
in the Indian National Congress nominated a candidate, the Mohtab Sheikh of Farakka constituency.
Please go and outside we grant, and it would be done, election commission will take care of it. as
Within the
quickly as
stipulated.
possible.
Only some precedents to this propose nominees. That will expedite the procedure.
Leave to the tribunal, they will do everything.
But Chacha, how many proposed nominee of a recognized political party is in such a situation?
Maybe not a very big number, not a very big number.
We had
but
14, all are clear, all clear.
let it be considered with precedence so that they can be on the fray.
Will assist the Chief Justice and his team to deal with all the logical discrepancies in which constituencies going to poll.
Within the.
We had 14, the 14s have been cleared.
No, maybe Indian National Congress has one.
Yes, yes, my lord.
They may have, not
Please
really. About not more than 10, not more than 10.
Chief Justice of the High Court has informed that the pending objections will most likely be adjudicated by 7th April 2026. So keeping the aforesaid date in mind, from oppose this matter on 6th April at 4 p.m.
Deeply obliged.
Yes. Grateful, extremely
Grateful, grateful.
grateful.
My lords, only one sentence. My issue may kindly be recorded.
Your issue is definitely there, sir. You are there. We are also alive.
Seven years completed under UAPA in Ranchi, and now it's been Delhi, doing time, 7 years in hospital.
But the learned ASG is appearing online, he may be unmuted for item 2.
10 years nearly is spent in custody. 2 orders of the Honorable High Court of Orissa. First, that the trial should end by December 23, and then that it should end by December 24. Have not been complied with. 25 witnesses out of 64 remain. 39 witnesses have taken 9 years.
Are you, madam, we hope that you are aware of the order which eventually we have succeeded in.
No, please, actually, this is what I want to say. If I can hand this over. Between December 2015 and January 2016, on the same.
Very good afternoon for everyone joining this broadcast. Very good afternoon. It was a very significant hearing which has happened in Supreme Court today. Yes, we all know that this is all about the SIR hearing, which it's safe to say had been extremely contentious over the past so many months, given the fact there had been large scale deletions. Now, the people who have been deleted either from the first draft list or in the due course of adjudication, they do have a constitutional and a democratic right to vote. And that has been reminded time and again, that people who have been deleted, and if that deletion is unfair, then what happens to their constitutional right, their democratic right to vote? And that found a special mention today. So yes, today when the hearing happened, a lot of things were actually building up in anticipation as what would be the outcome. To put things in perspective and to streamline the chronology, we know roughly about 60 lakh people had been sent to adjudication list, and these are the people who probably are already mapped, which was the Election Commission of India's own directive, that if you or your family members' names are there in the 2002 voter list, in that case you are mapped. So you need not furnish any further document in order to prove your legitimacy as a valid voter. But then happened logical discrepancy. Now, these logical discrepancies, even though had been veered to sound, to even comprehend, but these logical discrepancies have also led to the deletion of roughly about 45% of people who were sent for adjudication. Now, at this juncture, many people have been complaining that those who have been deleted unfairly, even after possessing documents like passport, even after possessing documents like land records, even after possessing like documents like bank accounts, even after possessing other government documents that identify their nationality, yet they have been deleted for reasons best known to Election Commission of India. And it's very, very important to say that the reasons are not known to voters, reasons are not known to anyone, reasons are only and only known to Election Commission of India, because the judicial officers who have decided to delete them have decided so relying on the documents which have been collected, collated, arranged and thereafter forwarded by the micro observers. Now, who are these micro observers? Handpicked by Election Commission of India. So that itself was a contentious matter given the kind of distrust which has existed between the state government and Election Commission of India. The reason why the matter went to the Supreme Court at the first place, that micro observers are trying to niddle in the entire SI exercise, who are mostly outsiders who have been brought into the exercise of West Bengal, SIR exercise of West Bengal, and that they are unfairly targeting people, unfairly isolating people, unfairly deleting people. The reason why the matter went to Supreme Court at the first place. Now, the decisions which were ideally supposed to be taken by ERO, after the matter went to Supreme Court, the change happened that instead of ERO, the decisions would be taken by the judicial officers. So, role of ERO got replaced and judicial officers came into the picture. But as far as role of micro observers are concerned, that role existed. So micro observers, what job they were doing, they continued doing so, in a way assisting the judicial officers to arrive at a decision. And it is very important to understand that those who have been sent for adjudication, they did not get a trial. They were not called for hearing, because this was not a tribunal. So now the judicial officers, whatever they are deciding, they're deciding on the existing documents, on the existing available materials, existing available observation and opinion of the micro observers. So judicial officers have adjudicated roughly about 46 lakh cases, which is more than 60% to 70% cases have been adjudicated. And the affirmative which had been given to the Supreme Court today, that by 7th of April, the remaining cases will also be adjudicated. Very good. Now let's come to the other crucial part. The other crucial part is those who are now being deleted by the judicial officers, what happens to them? Where do they seek redressal from? The answer to that is tribunal, as decided by the Supreme Court of India. Now, where is this tribunal? Is it Calcutta High Court or this court or that court or a trial court? Well, no. The tribunal is basically a quasi-judiciary setup which has to be now mechanically set up with the help of the Chief Justice of Calcutta High Court along with other judicial officers, for which 19 judges have been roped in, including former Chief Justices. Now, 19 judges and including former Chief Justices will be setting up this tribunal. It is almost like 19 courts, right? 19 separate courts. Now, these 19 separate courts will require a place to sit. The place has been identified. So, the first work to set up a tribunal to identify a place has now been, is now over. So there is a place in Kolkata, in Behala, near to Joka. That place has been identified and also approved. Over there, 19 judges, including former Chief Justices, will be taking trial of cases which have been deleted. That's the second outcome of today's hearing. A clarity which is now there. So the tribunal will now begin Today is 1st of April. The elections happen on 23rd and 29th of April. We exactly have 22 days in hand. And Advocate Divan, representing state of representing Mamata Banerjee, he kind of highlighted this particular concern. The tribunal possibly will now have the burden to handle cases in a huge number, and that too within a limited time space. Can all the matters be disposed of? Can all the matters be first heard and then elections can happen? That clarity is still not there. What you know as a matter of fact, the tribunal will possibly begin ASAP. The Election Commission of India has given this clarity before the Supreme Court that they have identified the places, the judges, and the tribunal is all good to go. So possibly it will happen tomorrow or day after, and thereafter the hearing would happen of all those people who have been deleted in the course of adjudication. The third very important point: what happens if they are not disposed of and elections come? What happens then? The answer lies in the very fact that Justice Jaimallo Bagchi had categorically stated that while the SIR exercise is important and you have trying to purify the voter list, but at the same time, those who have been deleted, they cannot be denied of their constitutional and democratic right forever. Otherwise, it will be very oppressive a thing. That's the word he has used. Oppressive a thing. So which means the tribunal can hear the matter, dispose them of, take its own course of time, not necessarily, and that would get over before elections happen in Bengal. And I say why? Because Election Commission of India has booked that place where the tribunal would be set up for 8 weeks. We are literally 3 weeks away from elections. So Election Commission of India has booked a place for 8 weeks, which means Election Commission of India will continue with the tribunal hearing exercise for 2 months. And in those 2 months, while people would be trying to clear out their file, struggling to come back to the voter list, they may succeed. They may succeed to come back to the voter list, but not necessarily will they be in a position to vote this time. That's the third most important outcome, which I realize, which I sense. While there is nothing said verbally by the judges, verbally by Election Commission of India, but there are certain things between the sheets. The question thus obviously is democracy delayed equivalent to democracy denied? Let's ask that question. The SIR exercise is a time-consuming exercise which Election Commission of India wanted to fulfill within 2 months. That's their call. And now, as the matter has landed up before the Supreme Court, no party can say that they are not responsible. The Election Commission of India is equally responsible for that. The state government is equally responsible for that because they have moved to the Supreme Court. And they had to go to the Supreme Court because both had been equally contributing to an environment of distrust. First you map people, then you push them to adjudication list. And then when there is distrust between the two systems, you question why is there distrust? When somebody is being questioned, the most bizarre and obnoxious question ever somebody has come across, as why 6 siblings share a common father and common parents, and if someone identifies that and calls out the abnormality in that question, you cannot say that you are wrong in distrusting the institution. Because that institution is asking me that obnoxious question that many would say deliberate. So now when the matter has gone to Supreme Court and it has taken the time it has taken, there is no clarity. Those who have been deleted, will they be ensured voting rights for Bengal election 2026 if they possess all valid documents? Point number 4, equally important. Advocate Bikash Ranjan Bhattacharya and also Advocate Kalyan Banerjee and Advocate Kapil Sibal, Senior Advocate Kapil Sibal, they all highlighted the fact that look, micro observers or the judicial officers have taken a decision relying on certain documents which is itself contested. For example, somebody who has a passport, he has been deleted. Can there be any bigger a proof of nationality than a passport? Yet somebody has been deleted, which means there are flaws at different levels and they are, they are there, it's confirmed. Now it is time to rectify those flaws. The reason why you have a tribunal. Now tribunal cannot operate only and only relying on a closed exercise which itself is flawed. For example, say a lower court has taken a decision. In a judicial matter, a lower court has found you guilty. Now, the lower court found you guilty depending on what the PP has submitted, depending on how your lawyer has argued, right? And evidence is available on the table. Now, from trial court, unhappy with the order, you move to the upper court, say Calcutta High Court. Now, before Calcutta High Court, you then present other evidences, right? To substantiate your argument. So every time you move from one court to another court, you are doing so clinging on to new evidences that you present before the judiciary, right? That scope has now been made available because Election Commission of India, even when tribunal is coming up, was very much opposed to the idea, let people go with fresh set of documents. The Election Commission of India had been saying that that may open Pandora's box. The Election Commission of India has decided on 13 documents. You need to give one of them to prove your legitimacy. Every individual has done that, yet people have been deleted in the first tranche from draft list. Then people have been deleted further, about 7 lakh people or 6 lakh people, depending on Form 7 and other investigation. And thereafter, you brought in another category, which is logical discrepancy, right? So Election Commission of India, relying on the set of documents which are there or which were made available by every voter, they had come to a conclusion, which is like a trial court. Now that conclusion is now being challenged before the tribunal, where every individual, if I am being deleted, I get a fair chance to go and represent my case, get myself heard. That's called a trial. Now, Election Commission of India is saying that you go there, stand. But when the hearing happens, you don't have to give any other document. Why? What happens to those people who have been deleted even after possessing, a passport? Should they not show that I hold a passport, Indian government issued passport, yet I've been deleted? Now, please answer Election Commission of India. So, Election Commission of India had very categorically tried blocking that very aspect. No more new documents, no more fresh set of documents. जो है वही है, उसी पे पूरा इन्वेस्टिगेशन हुआ है, उसी पे अभी ट्राइब्यूनल भी काम करेगा. क्यों? ऐसा हो गया तो ट्रायल कोर्ट की ऑर्डर कभी आप हाई कोर्ट पे चैलेंज ही नहीं कर पाओगे. ऐसा कोई रिस्ट्रिक्शंस होता है कि ट्रायल कोर्ट के जज के सामने जो सारे एविडेंसेस आए, वही सारे एविडेंस आपको हायर कोर्ट में ही रखना है. कोई एक्स्ट्रा एविडेंस आप नहीं दे सकते हो. सुप्रीम कोर्ट में गए आप एक्स्ट्रा एविडेंस नहीं दे सकते हो. How can there be restrictions put on, on the entire trial process? So now that clarity has come that documents subject to verification, I repeat, documents subject to verification will be accepted at the tribunal. Fresh documentation process will be allowed, but subject to verification. But subject to verification. Subject to verification. All right. So basically, that's the fourth clarity which has come. The fifth clarity is on Form 6. Over the past few days, there has been, lot of over the past few days, there has been lot of videos doing rounds, and those videos indicate that something is going on inside the CEO's office. All right, inside the CEO's office. Now, inside the CEO's office, people could be seen walking in with bunch of documents, and they are purportedly Form 6. Now, these Form 6 documents are not meant to be accepted at the CEO's office. Okay, so there had been a lot of dispute, lot of objections, and lot of controversies emanating from the CEO's office over the past few days. Now, that matter was highlighted before the bench of Supreme Court. That look, 30,000 Form 6 have been submitted, and these Form 6 documents should not be submitted there, and this is a proof of unfair practices happening inside the CEO's office. To which the Chief Justice of India, on a lighter note, said, everywhere it happens before election. Suddenly there is a barrage of Form 6 documents which come, and thereafter, you can raise your objections. Justice Joymallo Bagchi said something very important. That there is one thing, that is amendment to electoral roll, which is SIR exercise, right? And there is also an amendment to an electoral roll which goes to polling. The objection that was raised from the government of West Bengal side or Tribunal Congress side, that it is government of India or this is the Election Commission of India that has decided that on 1st of January, 1st of April, 1st of July and 1st of October, most probably, in that time frame, you can give Form 6 and get yourself uploaded in the voter database. That is a fair practice. But when you have election in one particular state, then there has to be a cutoff date, because nomination filing has a cutoff date. If your election is happening on 23rd of April, for which the nomination filing cutoff date is 6th of April, the law says 10 days prior to nomination filing is the last day before any Form 6 can be accepted from people who are dwelling in those constituencies which are going for elections in phase 1. So phase 1 constituencies, for those constituencies, Form 6 last cutoff date for Bengal election 2026 is, 10 days prior to 6th of April, which is when 10 days would be about 23rd of March. So that day is gone. For second phase, which is 29th of April, for which 9th of April is the nomination filing cutoff date, 30th of March was the last day when Form 6 could have been accepted. So now Form 6 has also become a very contentious issue, and that matter too was raised before the bench of Chief Justice and Justice Joymallo Bagchi. But then the Supreme Court said they are not holding on to that matter. That matter can go to some other court in some other bench, but not before them as of now. As of now, they're only trying to focus on the constitutional rights of people, the democratic rights of people, the tribunal functioning, the judges who would be part of the entire tribunal, their logistical support, the judicial officers who have been functioning all along, clearance of their payment. All of these things were highlighted today. We would try and do a detailed breakdown of what you have understood from today's hearing. It was a very critical hearing and a crucial one, and we would file a detailed report by evening. But for now, I thank you all for joining this broadcast. Minded 6th of April, the constitutional bench would be finally hearing this matter. And on 6th of April, probably we would also get a clarity as what happens to those who have been deleted now, waiting for a redressal before the tribunal. Hopefully the tribunal would start by then, And hopefully that would also give us a clarity, the pace and the speed at which the matter had been disposed of till 6th of April. And that would also give us a clarity as how long it possibly would take for all those cases impending before the tribunal. For now, a very big thanks for joining us in this broadcast. Do let us know your feedback. And of course, do let us know your feedback about the SIR exercise in Bengal. If you have been affected by this exercise in Bengal or outside, do leave your thoughts in the comment section. If there had been any peculiar situation you have encountered in this entire SIR process, do let your thoughts thoughts known to us through your feedback on the comment section. Any other idea, any other thought you have about the entire exercise, do leave your comment. And in case you agree with this exercise, let us know. For now, thank you so much. See you very soon.